Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning. It is Saturday, August 26, 2023. Thank you so much for joining me this morning on Morning Cannolis. 2 hours of our weekly review, our analysis, our discussion of those most important news events, those great stories in law, in government, and yes, the aspiration for justice in America. As always, we're coming to you this morning from the studios of Civic Media in downtown Waukesha, but we are broadcasting throughout this great state of Wisconsin. Welcome to our discussion this morning. As always, I'm joined in my studio by my wonderful producer, and her name is Anya. Together, we're taking your phone calls at 844-967-2789. That telephone number, once again, 844-967-2789. Also, you can text me and Anya through the Civic Media app. Get on the app, take a look at our show, identify the radio station through which you hear this broadcast, and be a part of our discussion this morning. As always, we have an ambitious but achievable agenda, an extensive but important syllabus this morning. I'm going to talk with you about that in just a moment or so. And we always ask 3 important questions. What do we know? What do we know about the facts of what has happened in this past week, this past month, sometimes even in the past year? Why are those things important? Why are they significant? Why are they relevant to the times in which we live? And what should we do about those things? What actions, what responses should we undertake in response to those things that are happening in our lives? As always, we're going to be asking and hopefully answering some, if not all, of those questions this morning. Once again, thank you so much for joining me this morning on Morning Cannolis. Let me tell you a bit about our ambitious but, again, achievable syllabus. We have not had a segment recently called Undiscovered Justice, and we're going to start that this morning. We're going to talk about 2 places in America. One of them, of course, right here in Wisconsin, but also in Minnesota, the state of Minnesota. We're going to go overseas to talk about something that's significant that happened this past week in Germany. Both of them related to some stories in the area of undiscovered justice on the face of this planet, locally and beyond. And then, of course, we're going to be doing some rule of law snapshots, everything coming out of the news of just this past week in places like Georgia and Washington, D.C., and other spots throughout our nation. And then we're going to return to our continuing review of these major allegations made against the former president, Donald Trump, principally, although not exclusively, in this major indictment coming out of a grand jury in the U.S. District Court in the District of Columbia. We have been spending the last couple of broadcasts talking in great detail, even reciting to some extent, the nature and the content and the focus of many of those allegations, the 4 principal counts against the former president pending in the federal case. Again, this different from the case pending out of Fulton County in Georgia, which we will also talk about this morning. We're going to go back and review some of those in the interest of giving some meat to the bones when it comes to what those indictments are all about. I think it's important, as I've said before, for people to understand that these are not simply allegations of broad criminal charges. They are that. But they're also animated by specific conversations and contacts and events that are described with great particularity in these indictments. And I think it's informative, regardless of how you come down. We always understand that every defendant, including the former president, is presumed innocent until established, until it is shown to a jury, a unanimous jury, beyond a reasonable doubt, that there is guilt attaching to one or more of these counts. But it is important, even along the way, to understand what the nature of those allegations are. It's not simply lawyers. It's not simply grand jurors talking about broad statutes. It is about things that happened in our recent national history. And I think it is significant that all of us take some inventory of what those conversations, what those actions, those events were, so that when we speak about the extent to which these indictments are important, and they are, not only presently, but also to the future of America, we've got some understanding of what animates them. What's the basis for them? What's the predicate for going forward, even in your own discussions among people with whom you agree, among people with whom you do not agree, to be able to talk about some of this. And so we're doing that again this second hour of our broadcast this morning, encouraging you once again to join Anya and me for that discussion. Phone number once again, 844-967-2789. Undiscovered justice. Some things outside of these recent focuses that we have had on the complaints and the indictments against the former president and many others involving January 6th, involving the Mar-a-Lago documents matter, involving an attempt to undermine justice in Manhattan, perhaps other places, both civilly and criminally there. We're going to talk this morning about two other instances out there, unrelated to those events, that underscore the significance of what can in fact happen in the area of justice, the importance of rule of law, promoting it in our nation, in our state, and throughout the face of the planet, across the face of the planet. We're going to begin initially by talking about Germany. And in Germany in particular, some major news having to do with the immigration laws in that country. Let's back into it this way. We know from our recent history that our own United States Congress, our government, our federal government generally, which is charged by the Constitution, the exclusive ambit, the exclusive area for its focus in the immigration area is federal. It is not a state matter, contrary to what some governors in the southern border may say. The matters related to immigration, not only border patrol and border enforcement, but also pathways to citizenship. All of those things that we talk about when we consider immigration in America, all of those are federal in nature. They're committed exclusively by our Constitution to the actions and the undertakings of our Congress, by our executive branch, and yes, as we've also learned, through our judicial branch as well, as they determine whether or not the actions of our legislature and our president are constitutional or not. And we have been frustrated in America by the fact that for many, many decades, we have not had the omnibus, the comprehensive kind of immigration reform that will address everything from border enforcement, which again continues to be both politically and socially a major issue in our nation, needs to be addressed in some way that ensures that people seeking asylum, seeking a passage into this nation through our southern and other borders, have a mechanism, a clear understanding of how the process works. And there is some order in a time when, unfortunately, we continue not to have order. And secondarily, for those immigrants who are here, legally, illegally, we've got a pathway forward. How do we handle their cases? We have not had a Congress in several decades that has been willing to wrestle dispositively, definitively with this issue. And so we continue to wander in this area of immigration in the United States of America without clarity. Germany, just this past week, is beginning to give us some way forward. What did Germany do to begin to address their own immigration issues as they go forward in addressing the things that they have on their docket? The German government, just this past week, the executive branch, if you will, presented a new citizenship law just this past Wednesday, the 23rd. And the legislation proposed by Interior Minister Nancy Faeser, Faeser is her name, will make dual citizenship easier, as well as naturalization for non-European Union citizens. Now, what's this all about? Well, she says, among other things, that this reform shows a commitment to a modern Germany. Again, invoking many of the things that we think about in terms of our own nation, the ways in which we should be contemporary and modern, and most importantly, human in addressing these uniquely human issues of immigration, people coming to the United States, in this case, coming to Germany. So what does the law say? What does this proposed new law envision in the nation of Germany, from which we can take perhaps some clues and some cues when it comes to the possibility of doing the same kinds of things? Not exactly. We've got different challenges. We've got different geographic circumstances, different population circumstances. But the notion here is that legislatures and governments can, in fact, act to address immigration issues. What does the German law say? Immigrants legally living in Germany will be allowed to apply for citizenship after 5 years rather than the current 8, reducing the number of years, collapsing, if you will, these long periods of time that we see here in the United States. collapsing that in Germany as well. If they have special achievements, that can go down to only 3 years, and those have to be defined, of course, legislatively and administered by their immigration authorities. But again, reducing the amount of time, which is a huge issue in Germany, but also here in our country, to administer and get these applications processed. Children born in Germany of at least one parent who's been living legally in the country for 5 or more years will automatically get German citizenship. Again, a different circumstance than what we have here, but we think about our own DACA young people, now not so young people anymore, but people looking for a way forward in this nation, brought here to our country at a time when they were very young. In Germany, children born in that nation of at least one parent who's been living in the country legally for 5 years automatically get German citizenship. Immigrants above the age of 67 will be able to do an oral instead of a written German language test, and multiple citizenships, as I indicated, will be allowed. People living entirely on state support will not be eligible for German citizenship. However, some other accommodations made along the way. And significantly, inside this important package coming out of Germany just this past week, German citizenship will be denied to people who have committed anti-Semitic, racist, xenophobic, or other defamatory offenses that are seen to be unreconcilable with commitment to the basic free democratic order established by the German population and the government there. A real fundamental notion that, again, you're not entitled to German citizenship. There's a process that will be streamlined. But if you are a part of a group, if you are espousing views that are contrary to what a democratic republic should be all about, you will not get citizenship there. Nonetheless, coming out of Germany this past week, and this major announcement of new legislation going to be debated in the parliament this coming fall, could take effect as soon as this fall, depending upon what the parliament does. Highly likely it will be passed there. What is the lesson for America? The lesson is simple. This can be done. This can be done, and we can do it in a bipartisan, non-political nature by coming together in a way that, yes, is practical. We don't all have to agree with every single aspect of the legislation. There are packages out there pending in Congress right now that could be the subject of meaningful review by committees on both the House side, the Senate side. All of that needs to happen. Let's follow the lesson of Germany and see if in America we can finally, across political aisles, on behalf of human beings, here legally, here illegally, work on getting natural and important immigration issues addressed. When we come back, we'll do the other important matter related to undiscovered justice. It comes from the state of Minnesota. Stay with us right after this break for that discussion of more undiscovered justice here on Morning Cannolis.
Sun in the sky.
And we are back on Morning Cannolis this Saturday, August 26, 2023. Thank you once again for joining me for these 2 hours of discussion, beginning this morning with a couple of stories, positive stories about things that can in fact happen in our nation, in our state, in our world. Undiscovered justice, a couple of things related to immigration laws being passed in Germany that enhance and promote diversity there in that nation, while also addressing matters related to the labor force and ensuring diversity in that area as well. Let's do one more story in the area of undiscovered justice, and that is in our neighboring state of Minnesota. Here's the headline on the story: people with felony convictions can now vote in Minnesota. A new law passed not so long ago in the state of Minnesota allows people with felony convictions, again, these are state convictions in the state of Minnesota, to vote, as long as they are not currently, at the time, incarcerated. Still do not include those folks who are still incarcerated. It expands voting rights in Minnesota, expanding the franchise to at least 55,000 people who up to now have not been able to vote because of this impediment imposed by state law, now stripped away. The Secretary of State there, a fellow named Steve Simon, said this is the largest single act of enfranchisement in over 50 years in our state. And he said that this is a Restore the Vote initiative, not only to establish that this right is out there, but also to move around the state and ensure that people who are, again, have recently been released from Minnesota prisons, who are no longer incarcerated, know about this right, so that they can register under the state of Minnesota laws, that they can vote in future elections. And that's also a part of this initiative. There's a fellow named Antonio Williams who's formerly incarcerated, and he's now a nonprofit director there in Minnesota. He spoke at the ceremony announcing all this. He said, after spending years of registering other people to vote, I will now be able to register myself. And indeed, many people in the state of Minnesota, again, approximately 55,000 people, now eligible to vote, based upon the enfranchisement granted them by the legislature, signed by the governor. A Democratic Representative Cedric Frazier of New Hope, Minnesota, championed all of this. He says, because what we know, that you've got strong and enduring democracies when you ensure that the vote, the franchise, the possibility of voting for your representatives in the state house, in the federal system as well, that encourages who we are as a nation. It will allow, he said, the voices of the people to be heard. And as a part of this, of course, we take some inventory of what else is out there. It turns out that there are 22 other states that do, in fact, restore voting rights when people with felony convictions leave prison. Again, not while you're in prison, but 22 other states, almost half of the states in our nation, do the same kind of thing. Minnesota now joining them. And that's according to the National Conference of State Legislatures. And that includes significantly North Dakota and Indiana and Utah, places that you may not otherwise think intuitively would have that kind of forward-looking law. The vote is a good thing, should be extended to people who, again, have paid their debt, as one often says, to society. They have lived up to the commitment to serve their time in prison imposed upon them by a state court judge, a federal court judge, and now they're free. And as a part of their rehabilitation, their reentry, as we say in law enforcement circles, into the community, their access to employment and education and healthcare and all those other things we think about when we think about citizenship and residency, whether it's in Minnesota or Wisconsin or the United States. Now you have access not only to those things, but also the right to elect the people who are going to represent you in the state house and indeed in the federal government as well. Some places like Maine and Vermont and the District of Columbia, there in those states, people with felony convictions who can vote while they're still in prison. Those three states, Maine, Vermont, and District of Columbia. So we've got a patchwork, if you will, of a number of different states out there that have these kinds of pieces of legislation, acts that have been passed by their legislatures, signed by their governors to ensure that the franchise is as broad as it is. On this broadcast, when we have chatted about the importance of the Voting Rights Act of 1965 and attempts still pending in our federal Congress to restore the basic trappings of it, sections 4 and 5, that have this pre-clearance procedure for those jurisdictions that have had a history of discrimination in voting. Also, Section 2, this basic fundamental notion inside the Voting Rights Act. Lots of things to do legislatively to ensure that the vote in America is as broad as it possibly can be. This event in Minnesota, an encouragement, undiscovered justice, because it's probably not at the top of the headlines in America this past week and even months, and going forward beyond that, to implement this in Minnesota, but an important movement once again in the insurance, the guarantee that people in our nation eligible to vote have the right to do so and are not disenfranchised by virtue of the past, but are permitted to do so as a part of their participation in citizenship in our great nation, in our great state. Undiscovered Justice in America, Morning Cannolis, Saturday, August 26, 2023. I promised that most of our time this morning would be spent chatting about, yes, the major news stories of this past week. Let me review some of those and then go back and talk in greater detail again about what happened, what we know, why these things are important. We're going to spend some time talking about these very significant, again, I would offer this tragic series of events we are now witnessing in America, having to do with the need, the absolute necessity to prosecute people, to prosecute people who attempted to undermine our republic, to stop the election from going forward in the way that people voted, and to substitute their own views about what should happen over and above the views of those people who did in fact vote in the majority. We're going to talk, number one, about what happened in Georgia this past week, including the surrenders of 19 defendants charged in that state indictment by the DA in Fulton County. We're going to talk beyond that about some significant events having to do with the Mar-a-Lago case. And yes, indeed, we're going to chat more about a matter having to do with the January 6th indictment coming out of Washington, D.C. And here's your teaser for the next segment as well. Some hearings coming up on Monday of great importance in at least two of those cases in the courts. More news coming up on Monday and more commentary coming up here on Morning Cannolis right after this break.
Stars when you shine, you know how I feel. Scent of the pine, you know how I feel.
We are back. Thank you once again for joining me this morning in our discussion about some of these major events of just this past week, including one coming out of Fulton County, Georgia. We know that as of yesterday, all of the 19 state defendants charged in the state indictment brought by a grand jury there in Fulton County, all 19 defendants have surrendered. And yes, all 19 have been booked. You can go online these days and you can see the booking photos and other information about each one of those 19, including lots and lots of lawyers reporting this past week to Fulton County to be processed by the sheriff there, pictures taken, photographs, and beyond that, other processing that's a part of the routine procedure, the rule of law process there in Fulton County, and I would offer in every other major state, local, and federal jurisdiction in our United States of America. All of them now processed as a part of the first steps in bringing to justice these individuals who are charged, again, presumed innocent until proven guilty, charged in this multiple count indictment, 19 people altogether, including, of course, in addition to those lawyers, the former president of the United States of America, Donald John Trump. Each one of them also charged with a violation of the Georgia RICO Act, the Racketeer Influenced and Corrupt Organization Act, along with many, many other things related to forgery and false statements, impersonating public officers, filing false documents, making false statements, all kinds of things, some of which we're going to talk about again today and in our future broadcasts as well. Among those people who have surrendered and now are a part of the process, they met the deadline for coming in on time, are two of those lawyers. Let's talk about them. Kenneth Chesebro and Sidney Powell, both of them, of course, a part of this scheme, allegedly under RICO, other allegations in the indictment against them and others for violating Georgia state law. Again, this is not a federal case. That's different. That's pending in Washington, D.C., much parallel, and we'll talk about that in just a few moments. Both of them, again, now a part of the process. Ken Chesebro, one of the lawyers who played the central role in developing the idea of having Trump supporters pretend to be electors from states won by Joe Biden, in fact, including authoring and being the architect of something called the Wisconsin Memorandum. We're going to talk later on about how that concept of initially having them be conditional, if you will, ultimately trying to supplant actually the real live, the true and credible electors from the state of Wisconsin and throughout other states. Ken Chesebro, again, brought into the system as of just this past week, along with Sidney Powell. Sidney Powell also identified by name in this indictment. She's also a lawyer, also charged with the RICO Act, computer theft, computer trespass, invasion of privacy, conspiracy to defraud the state, conspiracy to commit election fraud. Now, why do I bring both of those two among the entire 19 up? Because of the procedure that they appropriately invoked this past week. Through their lawyers, they have requested under state law an expedited, a speedy trial. Of course, every defendant in our nation, whether you're in the state system, in a federal system, has a right to a speedy trial. In this particular instance, under Georgia law, you can specially ask for that, and it means that the judge is pretty much compelled, in this case, to grant that request. And so, at least as to Chesebro, and probably as to Sidney Powell as well, very soon, the judge who's presiding over this matter, once again in Fulton County, one of the major figures the judge is in this entire matter. We'll talk about something else he did recently, also significant with respect to Donald Trump. He has established a trial date at least for these two out of the 19, Chesebro and Powell, for October 23rd. October 23rd of, yes, that's right, this year, in just a few weeks. And so Fani Willis has said, let's go. Let's try. She said, I am ready to try all 19. She has proposed, as we well know, a very expedited trial date. She wants to try all of them together. That probably will not happen. But she has indicated she will go ahead and she will present evidence of their crimes as soon as we can get into court, she says. And these two defendants have asked under state law for an expedited, a speedy trial. The judge has set that for October 23rd of this year, not next year, not 2025, not 2026, of this year. And so what are the consequences of that? Well, if indeed they go forward with this, they will be tried separate, presumably separate from the other 17 co-defendants charged in that indictment. Also significant to watch what happens here. They're plainly receiving now through their attorneys a huge amount of discovery. The indictment, as we well know, as we talked about before, is sweeping. It's broad. It is colossal. It is huge in its breadth. And one of the things that their attorneys are going to be doing, of course, in providing vigorous and effective representation, which is not only their right, but a requirement, a fundamental notion behind our system of justice, that everyone in a felony position there gets representation that is vigorous and effective. Note that right now. We'll come back to that in just a moment or so. Every single one of those defendants is entitled to have vigorous representation, which means review of all the documents, all the material that the government provides as a part of what's called discovery in this matter. It may well be that Mr. Chesebro, Ms. Powell may look at all this and say, well, gee, we can't get ready in time, either individually or through their counsel, and maybe they will withdraw those requests. But right now, as of this Saturday, they're on schedule to go to trial, and this case recently returned in October. The others, we do not have a trial date yet. And again, it underscores the fact that among these 19, many things will happen, some going to trial independent of others. Likely some of them may enter into plea agreements with the state that presumably would contemplate their agreeing to plead guilty to certain offense conduct, presumably in exchange for their testimony. All kinds of things can happen as this goes forward. My own sense that the final disposition of this case will not happen for many years, including final judgments reviewed by appeals courts, affirming presumably, again, convictions under the state law of Georgia. It is a compelling case, but it is broad and sweeping. As many others have noted, it's a lot to consume. We also know that the same judge who's granting that request for a speedy trial said something else with respect to another defendant earlier this week, and that defendant's name is Donald Trump. The judge this past week, just like Judge Chutkan did in the federal case pending in Washington, D.C., also imposed some restrictions upon Donald Trump especially. Why? Because we know about some of his conduct going out there speaking about the legitimacy of prosecutions, attacking prosecutors, suggesting witnesses are lying, suggesting the entire system is rigged in some way. And so this past week, that same judge imposed upon Donald Trump some requirements of his behavior, said specifically limiting the former president's social media use in connection with his indictment, 13 counts against him and his allies, as we know, in this effort to overturn the 2020 election. Fulton County Superior Judge, his name is Scott McAfee, M-C-A-F-E-E, signed an order banning Donald Trump from contacting any of his co-defendants or witnesses in the case except through their attorneys. Again, attorneys can do that. They're officers of the court, subject to rules and regulations. Donald Trump now told, don't you talk to any other defendants, witnesses. Don't be out there, likewise, intimidating any co-defendants or witnesses in the case, including, the judge said, on social media posts. Very similar to the kinds of things that Judge Chutkan said in the District of Columbia Court a couple of weeks ago. A judge in particular here in the Superior Court said the defendant, meaning Donald Trump, shall perform no act to intimidate any person known to him or her to be a co-defendant or witness in this case, or to otherwise obstruct the administration of justice. Judge went on to say the above shall include but are not limited to posts on social media or reposts of posts made by any other individual on social media. Sometimes referred to as a gag order. I'm not a big fan of that word because it suggests that your First Amendment rights are completely curtailed. They are not. This defendant, Donald Trump, are all of the other defendants in Georgia, any other defendants that might be charged in other jurisdictions, including the federal jurisdiction in Washington, D.C., they can be out there. They can talk about how they feel in their view of the evidence, their own positions that the case is against them is not strong. They can talk about how they look forward to their day in court, to their right to a trial by a jury of their peers, to present their evidence. They can do those kinds of things and advocate on their behalf in the social media context and in other ways. What you can't do is you cannot say things that suggest that witnesses should not testify, that there are consequences, as this defendant already has done, to their doing so. You can't threaten them. You can't be out there because not only is that in violation of the court rules, it is also a violation of the law. That's called obstruction of justice. And so once again, we've got a state court judge now just this past week who's saying, Mr. Trump, you better not do this, and setting down those rules. We will see. We will see. Just like the challenge before Judge Chutkan in the D.C. District Court, now we've got this challenge before Judge Scott McAfee to enforce that. And I suspect that both of them will in ways big, small, known and unknown to us in this process. So we'll look forward to seeing that as well. So we've got all of the 19 surrendered. We've got these two going to trial. We've got a statement to Donald Trump that he is not to intimidate witnesses, not to have contact with co-defendants in this case, seeing whether or not he can live up to that particular obligation. And then we also have something else going on coming out of Georgia. Again, a part of our rule of law snapshots this morning. We've got 5 of these defendants, 5 of these named defendants in the state indictment in Georgia, seeking to remove this case, to transfer it from the state court to a federal district court in Georgia. Now, is there a process for doing that? The answer is yes. There is a federal statute that basically says that if you are a federal officer or a federal agent and you are doing things in the scope of your duties and responsibilities, the things that you are charged to do, whether it's under the Constitution, under the statutes, by virtue of your oath of office, if you are exercising the duties and responsibilities of your office, things that we contemplate would be within the scope of your duties and responsibilities, not in your personal capacity, not in a political capacity, and certainly not criminal in nature. We don't send people to elected positions of office to engage in crimes and then permit them to use those actions as a way of getting around due process and all the other trappings of the rule of law. But if in fact you have done something and you are the subject of civil or criminal prosecution that implicates your actual practical exercise of your duties and responsibilities in that particular office, there's a mechanism for judges to look at that and say, well, gee, maybe that should be in federal court. Happens a lot in the civil context. Spent a lot of time when I was a civil chief, both here in eastern Wisconsin and also in western Michigan, making determinations about whether or not particular people, particular federal defendants had done something in the scope and breadth of their duties that qualified them not only to be in federal court, removing cases from state court to federal court, but also permitted the federal government to represent them and sometimes even substitute the United States of America for them. And so there are all sorts of remedies that come from that transfer. Here we have 5 of these named defendants, including, that's right, Mark Meadows, the former chief of staff, one of the principal defendants in this Georgia case. We know about him as well. Again, the former chief of staff for the former president a lot in the news these days. He is charged with one violation of the RICO Act and one count of solicitation of violation of oath by a public officer. Again, during a visit to Georgia, according to the indictment, he showed up at a vote counting facility, was not permitted entry. The authorities there said, nope, even though you're the chief of staff, can't come in. But he put Donald Trump on the phone with a top state election investigator in an attempt to get entry into that facility at the time, and presumably to try to have an impact upon the voting and the counting that was taking place there. Those are some of the violations charged against him. Mark Meadows and 4 others, including at least one of the fake electors, we'll get to her in just a moment, have sought a federal inclusion, if you will, an umbrella to bring this case into the federal court, bringing it from state court into the trappings of a federal district court there in Georgia. And so on Monday, mark your calendars for Monday, because on Monday, a federal judge in Georgia is going to entertain this argument offered principally by Mark Meadows, but also joined in by other defendants, to ask that this case, at least the portion of the case as to them, be removed from the state court into the federal court. What is the prediction on this? Highly, highly unlikely that a federal district court judge who does this routinely, who looks at these kinds of things civilly and yes, sometimes criminally, and determines whether or not particular federal officers, number one, are federal officers at the time of the conduct, and second, even if they are, is their conduct of the sort that is in the ambit of their actual duties and responsibilities? As I indicated already, got to do those thresholds, got to make those findings before you can transfer a case in. Welcome back to our last segment in this first hour of Morning Cannolis, and we're talking about the Georgia indictments against 19 defendants, including the former president, including at least 2, 3, 4, 5 of those defendants who are seeking to remove their cases from the state court into federal court. And yes, indeed, Ross, one of our great listeners, has sent a text to us asking that we comment about the circumstances under which this can happen, and that's what we're doing right now. Ross, thanks so much for your inquiry, your comment sent to us here at the studios by text. We appreciate your invitation to have this important discussion. Let's take up Ross's inquiry and pursue this a bit further. We know that in addition to the lawyers indicted, including Cheesebro and Powell, those who are, again, seeking this immediate trial coming up in October, and these 5 others now seeking to have the case transferred from state court to federal court, different kinds of things going on here, that among those 5 is one of the so-called fake electors. And we know that those fake electors identified by name specifically in this particular indictment. One of them is Kathy Latham. Another one is David Schaefer. Another one is Sean Still. All of them, all those 3, identified as people who knowingly and purposely engaged, number one, in a violation of the RICO Act there, but also engaged in this conspiracy to commit election fraud, forgery in the first degree, false statements, criminal attempt to commit the filing of false documents, computer theft, computer trespass, to defraud the state of Georgia. All of that alleged against these fake electors brought into, again, the state system there, very similar to the way that the AG, the Attorney General in the state of Michigan, another state prosecution, has likewise brought charges against the fake electors in that state. Here in Georgia, however, Kathy Latham, among those asking that her case, she's among the 5, be removed from the state court into federal court. And significantly, this push for the removal of the case, the movement into a federal court, premised upon her view that even though she wasn't a federal employee, that she was acting at the behest, the encouragement of a federal employee, presumably Donald Trump. She's saying that she also gets the protection of this particular statute by virtue of the fact that she was doing this on behalf of the federal authorities who are telling her to do this, whether it's the chief of staff, the president, others, presumably co-defendants, also telling her that this is something that they should do, that she says she possesses a right to have this case removed as an officer of the United States or a person acting under officers of the United States. I would offer to her and presumably to the federal judge is going to be looking at this. This is an extraordinarily broad interpretation. She is alleging that she is not an employee, but by virtue of the fact that she was told to do this by others, she's effectively deputized, if you will, in the federal system. The law, of course, permits, as I've indicated, a federal judge to take a look at these circumstances and determine whether the circumstances are such to believe this person was acting, again, as a federal employee in the scope and duties of their responsibilities, something that, again, I don't think any of those defendants will be able to show. But secondarily here, you've got a non-federal employee who's also seeking the protection of the federal law to get into state court. We will see. We will see what happens on Monday. And again, mark your calendars for one of two hearings Monday in the courts of America having to do with the disposition of these cases. Federal judge looking at this. Fascinating to see on Monday what the evidence will be presented by Mark Meadows, arguably these others, maybe including this particular false elector. What is the basis for asking for the removal of this? You have allegedly committed a state crime, and you are now seeking not only the protection of federal law, but you're maintaining that you did this in the scope and duties of your responsibilities or those assigned to you by people who are federal authorities. It is, at a minimum, a huge stretch. Prediction here that the federal judge will entertain the arguments. Will be interesting to see what kind of evidence is presented by these defendants. If they want to take the stand, they certainly can. They can testify on their own behalf. But when you're on the stand, you're also subject to what's called cross-examination, which means if they take the stand, whether it's Mark Meadows or Kathy Latham or anyone else who's there on Monday or future hearings, have also got to be subject to cross-examination by whom? By the prosecutors, who will certainly ask them about the circumstances under which they did this. Why? Hugely relevant, right, to a question of whether or not their particular conduct is covered by this federal statute that permits removal when, again, the circumstances are such to establish your duties and responsibilities. You're executing those as a way of getting these cases into federal court. Again, a stretch. We will see what the evidence says. We will see who testifies, who doesn't. And I would suspect by Monday or shortly thereafter, we'll know whether this skirmish off to the side, again, that the prosecutors in the state of Georgia have got to attend to, undeniably, is shut down as it probably should be routinely. And so we'll talk more about that down the road as well. We know as well that there's a second important hearing coming up on Monday, and it's also a reason to mark your calendar even while you're at work, doing other things with your family. Take note of this on your news feeds, and that is in the federal case. Again, this is the federal case, not the Georgia case. The federal case in which Donald Trump, singular defendant, has been charged with these 4 counts, also alleging violations of the federal law there. And Judge Chutkan, Tanya Chutkan, is having a hearing, and another important hearing on Monday. And what is the purpose of the hearing? It's called a pretrial conference. You get the parties together. In this case, it will not be the cast of 19 in Georgia. That's a different case. Those are different circumstances there. It's one defendant. It's Donald Trump and his lawyers, and it is the prosecutor, the federal prosecutor. It's Jack Smith, special counsel, and his colleagues in front of Judge Chutkan. And at that time, why are we anticipating this hearing with great anticipation? We're anticipating it because Judge Chutkan has announced that she is going to be taking under consideration and presumably announcing on Monday when the trial in that case, the federal case, will happen. We know that Donald Trump, through his attorneys, has asked for a trial in, yes, that's right, 2026. Highly unlikely that Judge Chutkan will do anything even approaching that. Jack Smith has offered January 2nd of, yes, 2024. Unlikely that is the date either. Sometime perhaps in 2024, if everything falls into place properly, she may be able to accomplish this trial, recognizing that she's got to find the time to do this, even with one defendant. Even the scope of this, jury selection presumably is going to take days, if not weeks. Opening statements, presentation by many, many witnesses. This trial alone will probably be weeks, if not months in duration. Got to find the time for that. She can plainly find that there is excludable time in what's called the Speedy Trial Act to schedule this as she will. And she has said to Donald Trump and to the attorneys involved in all of this that indeed she will move this case along expeditiously. Lots of things have got to happen in the coming months, including motions to dismiss, motions to suppress, all kinds of pretrial proceedings. But we will look to Judge Chutkan on Monday to determine what she does in the midst of all of this. And when we come back at the top of our second hour, we're going to take some of your phone calls about this and more, and then we're going to move into other matters related to these indictments here on Morning Cannolis. Stay with us in our second hour as we discuss the rule of law, justice, and government in this nation of ours.
So darling, save the last dance for me. Oh, baby, won't you save the last dance for me? Ooh, you make a promise that you'll save the last dance for me.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning and welcome to this, our second hour here on Saturday morning, talking about all sorts of things related to indictments in our nation, state indictments, federal indictments, charges, and pending in state courts, federal courts. Right before the break, after our first hour, we're chatting about this proposed process by which several defendants in the state prosecution, subject to the state indictment in Fulton County, are seeking to have their case removed from the state court to federal court, talking about the trappings of doing that. And in particular, we've got some great questions coming in on text, including one from Kathy in Forest Park, Illinois. And Kathy, appreciate very much your comment. Basically, Kathy's question is what are the benefits of doing this? Why would you go down this road? What are the benefits of going from state to federal court? And Kathy has identified at least one of those. Preface all this by saying this is not unprecedented, but a lot of this has to do with decisions that are going to be made by judges, certainly not by me, but as a result of the advocacy of attorneys for the prosecution, advocacy by attorneys for the defense. Everyone is going to be involved in this process, and in the end, the ultimate answers will come from judges who will tell us what the consequences of all of this may be. However, we know that what happened. I know a lot about what happens in federal court, including state court as well. Some of the things that plainly are a part of the overall consideration is that if you go into federal court, presumably in Georgia there, you may in fact have, some people have commented, a more lenient jury pool that may be more sympathetic to one that would be assembled in Fulton County, which includes Atlanta. And there in Atlanta, about 73% of the voters in the 2020 election voted for President Biden, over 26% for Trump. So there may be some strategic sense that, your jury might be more inclined to vote, again, based upon the evidence presented, to acquit. If indeed you might be more sympathetic to Donald Trump as opposed to Joe Biden. That's a purely strategic thing, not a legal thing. A federal case could also allow several of the defendants, perhaps in that forum, to test the limits of the Georgia RICO statute. Again, understanding, very importantly, that you don't get a brand new federal case. It's the state case that gets transferred into the federal court, as peculiar as that sounds, and you'll have a federal judge basically presiding over this case, if indeed it happens. But again, you might have some opportunity to challenge the RICO statute there, and ask questions through motions to dismiss, motions to define what the nature of that is in front of a federal as opposed to a state court judge. And then Kathy has also suggested another matter that may be down the road in terms of strategy and process, and that is, gosh, if you get a conviction in the federal court as opposed to the state court, could a future president pardon anyone who is convicted in that federal forum, admittedly still based upon that state prosecution? And the answer would be, again, presuming that the federal judge would impose a federal sentence, serving in her or his capacity as a federal jurist, imposing a federal judgment, a federal finding of guilt, and imposing a sentence. that could be subject to a federal pardon, a reprieve by a future president. Now, we don't know if all that's going to happen. And again, stripping all this back, my own sense is that the judge will push all of this back and will not bring this case into federal court. But these are fascinating civics questions to ask, fascinating law questions to ask, process and procedure questions to ask. And it goes back to my general concept that how tragic it is that we have to have these questions answered and asked, right? Our nation right now is in this posture where we're spending our time and our focus appropriately responding to criminal conduct conducted by people who wanted to undermine our legislative process, our electoral college, and skew the vote, and not only undermine but overthrow the vote. Nonetheless, significant that we're now spending our state time, our federal time, addressing people who do not understand the fundamentals of civics, the fundamentals of what our Constitution contemplates, and the notion that our voting system does envision a winner and, yes, a loser. And you don't try to get around it by engaging in criminal conduct, which is what all of these indictments, both the federal indictment in Washington, D.C., and the state indictment in Georgia, basically allege. Great questions being presented this morning. Let's go to some folks who are on the line as well. Let's begin with John in Milwaukee. John, you've been on the line for a while. Appreciate your being a part of our discussion this morning on Morning Cannolis.
Hi, I appreciate your show. The show you and your producer are doing is straight out of the top drawer as usual. I have a question about a theory that I've heard floated out there that with Trump's Jack Smith charges and now the Georgia charges, that there might be some criticism that there is overcharging or stacking, that the charges against Trump in Georgia are redundant to the ones that are brought against him in Washington, D.C. already. And I was just wondering how, is there anything to that? Would you address that argument?
Sure, John, it's a great question. I think there are two answers to it. Let me give you the civics answer, since we're doing a lot of that, a lot of law school this morning. Great question, John. Appreciate the comment, the inquiry. The narrow but significant answer is there's nothing that prevents a federal court, a federal prosecutor from prosecuting under a situation based upon acts that are also the subject of a state prosecution. The law is very clear on that. The Supreme Court has said that these are two different jurisdictions. You've got a federal court, and there are federal laws, and you can be prosecuted under those. You can also be prosecuted under the state systems around our country. Obviously, 50 states and territories, that sort of thing. Nothing legally to prevent that. So there's that issue generally. And there is also a policy you should know inside the Department of Justice called the Petit or Petite policy, based upon some long-standing tradition that basically says that in many cases, there will be some deference. We often let the state prosecutors go ahead first to see if whether state interests can be vindicated through a state criminal prosecution. That happens a lot when it comes especially to civil rights cases, and not only involving police officers, but individuals who might violate the civil rights of people. We often defer in the federal system to the state prosecution. Doesn't preclude a contemporaneous prosecution or certainly a subsequent prosecution, but you often make the assessment about whether or not in the wake, say, for example, of a state prosecution, it makes good resource allocation sense to pursue a federal prosecution. If indeed the defendant or defendants are going to spend some time in prison, if the general interests of the rule of law are vindicated, it may well be that resources are better spent in some other areas. But the narrow answer, again, is nothing to preclude a subsequent or contemporaneous prosecution. Why? Because you've got different jurisdictions, you've got different schemes, if you will. I mean that in a positive sense. Schemes of rule of law in America. Different rules and regulations. The case in Georgia is prosecuted under Georgia law. The case in Washington, D.C., prosecuted under federal law. Again, nothing to preclude that, aside from some policy considerations and strategic considerations. That's number one. The issue that I think, John, you also identify is just the public domain issue. It may well be that America, after all of these cases are going forward, and again, they're going to take years and years to resolve dispositively after appeals are taken in the state court and the federal court. There may be some sense down the road that we've done enough, that if indeed there's a sense of justice among the public, that there could be some decision making going on in the federal system, the state system, about whether to continue to prosecute those cases. But those are discretionary decisions, and they're made only after the rules of both the state systems and the federal systems are invoked, after the wheels of justice, if you will, are permitted to go forward. And again, probably more of a public domain kind of discussion of the kind that prompts your very good question, John, about stacking or overcharging. The narrow answer is no overcharging here, nothing to preclude one and the other. And it's only if in your perception as these matters go forward that kind of concern would have an implication for a legal decision here as well. So thank you very much, John, for that important question or comment. Appreciate that very, very much. We've got some other callers and other folks sending us some notes on text, which we appreciate tremendously. Joe from Madison, you're calling in this morning. Glad to hear from you, Joe, about any of these important topics.
I would like to echo the sentiments of your previous caller. Just great information, and I also greatly appreciated the two pieces that you started the hour with, your undiscovered justice. They were very helpful, the information on Minnesota and felons voting, and also Germany and their changes in immigration laws. Thank you for that.
Absolutely.
My question is as follows. Okay, I'm looking at the situation in Georgia with Fani Willis, and your reaction as a prosecutor, somebody who has prosecuted cases at the federal level, of course, but state level, I imagine it would be the same thing, that you don't go forward with prosecuting a case because it's so expensive and all, unless you're really, really sure that you're going to win. I mean, you don't want to have holes in it and be overcome. My question in pertaining to this would be then, I got to believe that Fani Willis just has nearly an airtight case, because not only she would be also have the focus on her of national attention and the political side of all of this. Why did you go forward if you didn't have an airtight case? So I'm curious, and maybe this isn't something you want to do this hour, but another time, as a prosecutor, looking at what you see that Fani Willis has at this point, do you think she has any worries at all about people changing testimony or problems coming up, in part because of that situation in Georgia where people can be so easily identified, the jurors could be identified, they have been identified. I'm interested in your comments on that, and I'll take my answer off air. Thanks very much, Jim. Appreciate it.
Absolutely, Joe. Great comments, and we're going to take that up right now because, indeed, it's on my syllabus this morning to chat about exactly that kind of thing. It's an important question, not at all to be deferred, and again, it's going to be the subject plenty of a lot of discussion down the road. I will tell you that any federal prosecutor, virtually all state prosecutors, even though the standard at the time of charging is probable cause, you don't have to have proof beyond a reasonable doubt at the time of charging, as a policy matter internal to the process of the prosecution office, before you decide to seek an indictment, you've got sufficient evidence. You believe that you'll be able to present this case beyond a reasonable doubt to a jury at that level. And so, yes, indeed, to use your language, Joe, Fani Willis has got compelling, not only information and evidence to present this case. She is strong in that belief, and she would not have brought this with respect to the second grand jury absent her commitment to this case. Right after the break, I'm going to tell you more about that, Joe, and all the other listeners, because it's such an important notion going forward. How do prosecutors behave? And in particular, what about this question of this very broad indictment and the possibility of witnesses, again, being intimidated? We'll chat about all of that right after this break.
Well, you can cry me a river.
We are back this morning on Morning Cannolis, and we are in the midst of a terrific discussion with callers, with listeners posing a number of terrific questions about what could and could not happen with respect to these federal and state indictments involving January 6th and other matters as well. And right before the break, talking with Joe from Madison, who raised these very significant questions about prosecutorial discretion, but also prosecutorial decision-making along the way. And right before the break, commenting that it is a general practice not prescribed by law, not prescribed by courts, but the prosecutors, before they go public, have a strong commitment to the case. This is not a situation most often, typically not a case where you go ahead and simply charge and see how things play out. You present cases to grand juries, you seek charges when you've got a very strong case. In the federal system, our general internal policy has been that, with some exceptions around the edges, anticipating maybe some development of witnesses and some other evidence coming in, we're ready to go to trial. We're ready to go to prove to a jury beyond a reasonable doubt that the charges in the indictment can be proved, even though, once again, at the time the charges are issued, the standard is probable cause for a grand jury. Obviously, before a trial jury, unanimity by that jury beyond a reasonable doubt. That's our process. Defendants presumed innocent until proven guilty, a judge guilty by a jury of their peers. Even so, the indictment in Georgia is broad. 161 different instances, if you will, of violations of RICO. Now, under Georgia law, Fani Willis does not have to establish more than 2 of those, but she's got them all set forth in this indictment and coming out of the grand jury. And without knowing anything more than you do publicly, and not having reviewed the discovery in this matter, nor will I, nor any of us presumably listening to this broadcast this morning, fairly confident, completely confident, candidly, that Fani Willis has got information to support each and every one of those specific instances, the 161 instances of RICO violations. She's got broad counts here. She's got all sorts of things alleged against these multiple defendants. And she, as I said earlier, she is ready to go. And whether this is going to happen, that is a trial of 19 defendants in one trial very soon, probably unlikely. She probably appreciates that as well. Nonetheless, a very strong sense that the case itself, sweeping and broad, is a significant case. It is a strong case, and regardless of when she brings this to trial, a strong sense that she will be able to present a sufficient amount of evidence to prove to a jury that she has got the evidence to support to prove her case beyond a reasonable doubt. Joe's other related comment, what about intimidation? What about things being done by one of the defendants, perhaps Donald Trump, maybe other people out there, plainly, threats being made against grand jurors in Georgia, against the sheriff, who is a now major part of this as well. A couple of observations about that. Number one, completely antithetical to our system. Those things may in and of themselves be crimes under federal and state law, depending upon the circumstances. We know, for example, that there's one woman in Texas who's already threatened a federal judge. Her name is Tanya Chutkan. She is in federal custody now. She's subject to a federal charge for doing that kind of thing. And the response, Joe and others, is when people do that because of the need to support the integrity of the system, incredibly important that they be identified, and if there is a sufficient basis to charge them, that there be a response to that. That's called deterrence, right? You deter the individual from doing that conduct down the road. You stop them, and you also send the message to anybody else out there who might think of doing the same thing. That's general deterrence, which we've talked about at great length in this broadcast. You want to send the message that if you're going to intimidate witnesses, you're going to try to impact the ultimate decision by jurors, by the people who are the triers of fact in this case, you won't get away with it. And you yourself will be sanctioned by the system. And Fani Willis has got to be responsible for all of that. It is a lot, undeniably. But that's her responsibility, and she will be attentive to this, as will all of her staff. She's not doing this alone, obviously. She's got a team there that we have seen on the news regularly. But she's got a lot to do here. Nonetheless, up to the task. And from my perspective, again, miles and miles away here in Wisconsin, but nonetheless appreciating what it is like to be presenting to the public an indictment of this breadth and this scope. She is ready to go, and she will be presenting this case, doing all the things she needs to do to protect the legitimacy of those witnesses and of the process generally. We've got another caller. Mark, you've been waiting on the line for a long time. Mark, your comment or question also this morning about any of our topics.
Yeah, because it sounds like the Georgia case is pretty airtight, and and she's pointed out, and it's brought into highlighted attention that this has been a nationwide conspiracy. I mean, they actually labeled it the Wisconsin plan, because it's not just Georgia, Michigan, and Wisconsin. It's also the state of Arizona, and other states actually did this whole fake electors thing. And now with Ron Johnson coming out, I believe it was yesterday, or was it Thursday, that he actually had a roundtable, actually more or less confessed to the Wisconsin fake electors conspiracy. He said, "Well, that was just political activity. It wasn't really, something intentional or anything like this." But my point would be is that from my read of Wisconsin Constitution, I think it's 775, which folds into it federal election law, which requires under the 14th Amendment, Section 2, that the right to vote, if it's interfered with, the right to vote for electors, including the electors, that is denied or abridged in any way, that it's a violation. And now it doesn't say that the results of those have to, it's by implication, the results of those votes are supposed to be respected as well. And it's clear to me that they chose to do this because they were thinking that, well, maybe we can get away with this. But by the Supreme Court decision on that same day the fake electors met, is that the Supreme Court in Wisconsin already said, nope, Joe Biden won the election.
Almost contemporaneous with the very conduct. Absolutely, Mark. And right after this break, I'm going to comment on your good comments and questions. Stay on the line, and everyone, stay with us for that further discussion. We'll talk more about the fake electors, what it says in the federal indictment, and again, as Mark, you've indicated, the intersection only with our senior senator, but also with state law as well. Stay with us for that discussion.
Say you love me. Well, just to prove that you do, come on and cry me a river. Oh, cry me a river. Well, it's a marvelous night for a moon dance with the stars up above in your eyes. A fantabulous night.
We are back here on Morning Cannolis. We're chatting about a number of different procedural issues, some civics issues related to understanding these indictments pending principally in Georgia, but then also in Washington, D.C. Appreciate tremendously the calls, the questions about all this. Right before the break, talking with Mark about his very good and observant comments about the intersection, if you will, between state law and federal law. We know that is reflected in major portions, also by virtue of the fact that some of the same conduct is charged in both the state case coming out of Fulton County and in the federal indictment coming out of the U.S. District Court, the U.S. District Court grand jury in Washington, D.C. as well. Along the way, we know that in the state case, we've got at least 3 fake electors. Their names are Kathy Latham and David Schaefer, and then also Sean Still, all of them identified by name. They are identified as co-defendants. Kathy Latham, we talked about her earlier in the first hour here this morning on Morning Cannolis, former head of the Republican Party in rural Coffee County, which also looms large in that indictment coming out of Georgia. She is allegedly involved in this effort by pro-Trump forces to copy some sensitive election software in January of 2021. Also, in addition to that, among the 16 fake electors in Georgia who cast their electoral votes for Donald Trump, she's facing 11 different charges, including things like false documents, forgery in the first degree, election fraud. David Schaefer, former state senator there in Georgia, former chair of the Republican Party, portraying himself as the chairperson of the Electoral College of Georgia. He filed 16 fake electoral votes for Donald Trump, and former Vice President Mike Pence facing 8 charges similar to those facing Miss Latham as well. The third person identified in that indictment in Georgia, Sean Still, Georgia's state senator, one of these bogus electors who sought to keep Donald Trump in power after the loss to Joe Biden. He's facing 7 charges, including forgery in the first degree, false statements, impersonating a public officer, criminal attempt to commit filing of false documents. All those things in that particular indictment coming out of Fulton County, plainly premised once again upon state law. But we know as well, based upon the allegations kind of in the core, if you will, of the federal indictment, which is what Mark was also making reference to, that we've got a lot of federal violations here as well. Recall once again that in the federal case, unlike the state case, in the federal case there is one defendant, at least so far. We've got these 6 unindicted co-conspirators, not named by name in the indictment, but we know who they are. They're Rudy Giuliani, John Eastman, Sidney Powell, Jeffrey Clark. Jeffrey Clark, this former DOJ officer who also attempted in the latter days of the Trump administration to become the Attorney General, basically due to the bidding of the president at that time to try to overthrow the results of this election. A major portion of the federal indictment describing his involvement, his criminal conduct in an attempt to accomplish the scheme. Kenneth Chesbrough, we talked about before, and then this Boris Epstein, who is an advisor to all this. Those are the 6 unnamed, but nonetheless unindicted co-conspirators set forth in that federal indictment. And the federal indictment also focuses on false electors. And a major portion, again, right in the middle of the indictment. The plan, this overall plan described in the federal indictment, it says capitalized on ideas presented by co-conspirator number 5. Co-conspirator number 5 is Chesbrough. He's the one who wrote what's called this Wisconsin Memorandum. And in that memorandum, November 18th, he advocated that because of the ongoing recount at that time, again, later resolved in favor of Joe Biden, Chesbrough wrote this memorandum, and he proposed at that time that they should meet and cast votes on December 14th, the date that the Electoral College Act required that they vote, to preserve at that time, and notice how this changes in terms of its intent, the Wisconsin Memorandum written by Chesbrough to preserve the alternative of the defendant's Wisconsin electoral state. And then after that, again, according to the federal indictment, this gets worse. The memorandum evolved over time from a legal strategy, arguably a legal strategy, to preserve the defendant's rights to a corrupt plan to subvert the federal government function. And that's what Mark was talking about when it comes to, again, this intersection between state involvement, federal involvement, by stopping Biden's electors, their votes from being counted and certified. So the indictment, again, the federal indictment, goes on to describe this false elector scheme, not naming them by name, not the false electors in Wisconsin or in Michigan or in Georgia or the other states, but identifying the nature of the false elector scheme. December 6th memorandum, this one's called the Fraudulent Elector Memorandum, marked a sharp departure from Kenneth Chesbrough's Wisconsin memorandum. Why? Moving from something that maybe could have been arguably legal, but now advocating that the alternative electors originally conceived to preserve rights in Wisconsin instead be used in a number of states as fraudulent electors to prevent Joe Biden from receiving the 270 electoral votes necessary to secure the presidency. The Fraudulent Elector Memorandum, again, describing this broad scheme, not just in Wisconsin, not just in Georgia, not just in Michigan, but throughout the country, suggesting that Donald Trump's electors in 6 of the purportedly contested states should meet and mimic as best as possible the actions of the legitimate electors, and that on January 6th, the Vice President, Mike Pence, should open and count those fraudulent mimicked votes, setting up a fake controversy that would derail the proper certification of Biden as a president-elect. What are those particular states? Here they are: Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin. That's the core, if you will, of the fake elector allegation, again, mirroring much of what we're seeing now in Georgia, the specifics as to those 3. This overall scheme described, again, with great particularity in Georgia, but also in the federal indictment as well. The memorandum, again, this Fraudulent Elector Memorandum, which is the product of Ken Chesbrough's pen, on how fraudulent electors could mimic these electoral, the legitimate electoral voters there. It noted that in some states it would be virtually impossible for fraudulent electors to successfully take the steps as the legitimate electors because state law required formal participation in the process by state officials or access to those resources. Again, acknowledging that what you're doing is probably not going to work. It did not, but nonetheless advancing it nonetheless. And sure enough, the allegations in the federal indictment go on to describe just that. Begins in early December. Again, these 2 memorandums, conspirators and Donald Trump's campaign took the Wisconsin memorandum expanded it to any state that Donald Trump was contesting. Even New Mexico, it says, where Donald Trump had lost by more than 10% of the popular vote. The expansion was forecast by emails from Donald Trump's chief of staff that were sent on December 6th, forwarding the Wisconsin memorandum to campaign staff. And again, this is the chief of staff about whom we have spoken earlier. He says this: we just need to have something coordinating the electors for states. He's sending out this document that plainly advances an attempt to undermine the process. That's the reason why Mark Meadows is in the trouble that he is, not only in the state of Georgia, but presumably also in the federal system as well. And then we get this involvement of the Republican National Committee, also described inside the indictment federally. December 6th, defendant named Donald Trump and John Eastman, again, the author of much of this, the architect of much of this, called the chairwoman of the Republican National Committee, we know her name is Ronna McDaniel, to ensure that this plan was in motion. Okay, we got this underway as of early December. During that call, John Eastman, again, at the encouragement of the principal defendant there, the Donald Trump, told Ronna McDaniel that it was important for the RNC to help keep Donald Trump's to keep the electors gathered together in those targeted states, and he falsely represented to her that those electoral votes could be used only if ongoing litigation in one of those states changed the results of in Donald Trump's favor. And after the RNC chairwoman, again, Ronna McDaniel, consulted the campaign and heard that work on gathering electors was underway, she called and reported this information directly to whom? To Donald Trump, who responded approvingly. The scheme is underway. The fraud is underway, described again with great particularity. December 7th, Rudy Giuliani received the Wisconsin memorandum and the fraudulent elector memorandum, again, the product of the attorneys and Kenneth Chesebro in particular. Rudy Giuliani speaks with Boris Epshteyn regarding attorneys who could assist in this fraudulent plan in those targeted states, including Wisconsin. And the next day, December 8th, Kenneth Chesebro calls the Arizona attorney on the list of Boris Epstein's list, if you will, people who will be involved in this, and says that we've got to pursue this effort. The indictment goes on again in great detail. To manage the plan in Pennsylvania, for example, on December 12th, again, Rudy Giuliani and Kenneth Chesebro and Boris Epshteyn participated in a conference call organized by the Trump campaign with the Trump electors in that state. And when Donald Trump's electors expressed concern about signing significant certificates representing themselves as legitimate electors, again, people looking at this and saying, this can't be real. We're asked to sign something that we're indicating that we're not who we say we are. What happens at that time is Rudy Giuliani falsely assures them that their certificates would be used only if Donald Trump succeeded in litigation. After that, co-conspirator 6, that's Boris Epshteyn, proposed conditional language to that effect for potential inclusion in some of those certificates. Campaign official cautioned not to offer the conditional language to other states because why? Those other states, according to the indictment, are signing what he prepared. If it goes out, we change the language for Pennsylvania, it could snowball. In other words, if we've got conditional language there, we might have to do it in other states, including the state of Wisconsin. And in some instances, to their credit, the proposed false electors in Pennsylvania refused to participate in the plan. And on December 13th, as a part, once again, of the allegations in the complaint, the indictment in the federal system, co-conspirator number 5, Kenneth Chesebro and Rudy Giuliani sent an email memorandum that further confirmed their plan, that it was not to use the fraudulent electors only in the circumstances in which the defendant, Donald Trump, the litigation was successful in one of the targeted states. Instead, it becomes very clear, based upon the evidence presented in this indictment, presumably to the grand jury, and that Jack Smith will present to a trial jury whenever this case goes to trial, that the plan was intended to falsely present the fraudulent slates as an alternative to the legitimate states here in Wisconsin and the other states at Congress's certification proceeding. That was the purpose of this scheme. That's what they were intending to do. December 14th, at the direction of Donald Trump and Rudy Giuliani, the fraudulent electors convened sham proceedings in 7 targeted states to cast fraudulent electors in favor of the defendant, Donald Trump. In some states, in order to satisfy legal requirements set forth for legitimate electors under state law, state officials were enlisted to provide the fraudulent electors access to Capitol buildings so that they could gather and vote there. And we saw that in the media at the time that was happening. In many cases, however, as co-conspirator number 5, Kenneth Chesebro, had predicted in his own memorandum, the fraudulent electors were unable to satisfy the legal requirements. Why? Because he knew that this was all fraud. And that's a part of the allegations in this overall indictment. A major piece of the indictment in the federal system premised upon this fundamental notion that the fraudulent electors, pretty much from start to finish, or very shortly after this concept was first hatched, intended to undermine our system, and this movement from an arguably legitimate basis to one that was known to be fraudulent by the defendant, Donald Trump, and yes, all of his co-conspirators, takes place. We also know, looking more into the kinds of things that Mark testified and talked about, that based upon testimony given to the grand jury, that our own senior senator may have been involved in some of this as well, that is the hand delivery of these. And so we see later on, when the indictment describes in great detail the events of January 6th, what specifically happened involving our senator, our senior senator, and a member of his staff in an attempt to get those false electoral votes into the well of the Capitol and onto the desk of the Vice President and the Speaker of the House. When we come back, we'll talk about that particular allegation in this compelling federal indictment right after this break here on Morning Cannolis.
My love, I just want one more moon dance with you. Yes, I do. Call me irresponsible.
We are back in this, our final segment here on Morning Cannolis. Thank you for once again listening in, joining me in this good conversation, this important conversation about what is charged in these indictments coming out of Georgia and also in the federal system. I hasten to add once again, as we always do, defendants, all of them presumed innocent until proven guilty. The standard there, beyond a reasonable doubt. And that will presumably happen at some point. That is a trial in front of a jury required to wrestle with the question about whether or not the government has proven its case. Defendants in America, rightly, appropriately, have no obligation whatsoever to present any defense whatsoever. Also entitled to a defense, a vigorous and important defense in the presentation of their case. And so all of that is a part of our examination. Right before the break, we're talking about the false electors. They loom large, plainly, in the Georgia complaint, the Georgia indictment. They also are described with great particularity in the so-called talking indictment coming out of Washington, D.C. and the grand jury there, spending some time right before the break chatting about the mechanisms through which these memorandums, the lawyers involved, Cheeseman and Giuliani and John Eastman and this advisor, Boris Epstein, to try to accomplish this in the various states, including right here in the state of Wisconsin. We now have out there in America 2 states that have not only identified this scheme as being contrary to their law, but also identified false electors by name. And those states are, of course, Michigan and also Georgia. And those people are now facing prosecution, will be required to stand before the bar of the court, if you will, in front of a jury, and have the prosecution advance its evidence in those particular events, those particular undertakings as well, supported presumably by the events described in the indictments. As a part of this particular indictment coming out of Washington, D.C., we also have, related to not only the Wisconsin memorandum, the Wisconsin false electors, the way in which Wisconsin itself looms large in this federal indictment. It's also mentioned prominently, of course, in the Georgia indictment, as Mark indicated in his comments a few moments ago. This description by the grand jury in Georgia of the nationwide effort to undermine the vote has its locus, its focus, if you will, in Georgia, according to that indictment, but it's all over the states, including the 6 or 7, including Wisconsin, identified similarly in the federal indictment too. And so we know about a lot of things that happened based upon the allegations, once again, in the federal grand jury, that Wisconsin was also involved through its senior senator in some of these events as well. On the morning of January 6th, an agent of the president contacts a United States senator. That's Ron Johnson. This according to paragraph 101 on page 37 of the indictment. We're now talking about things happening on January 6th. We've got events described there, the ellipse, the presentations by Rudy Giuliani and John Eastman. You recall them well, the president himself at that time speaking to the crowd on the ellipse before the insurrection, before the riot, before the death, before the violence, the insurrection at the Capitol happens. On that morning, we know, according to the allegations in the indictment, that an agent of Donald Trump's contacts a United States senator, that's Ron Johnson, and asks him to hand deliver documents to the vice president. He plainly has access by virtue of the fact that he is a United States senator. That agent then facilitated the receipt by a member of the senator's staff of the fraudulent certificates signed by Donald Trump's fraudulent electors in Michigan and Wisconsin. Once again, Wisconsin looming large in this process. And again, those certificates signed by Donald Trump's fraudulent electors in Michigan, Wisconsin, which were believed not to have been delivered to the vice president or the archivist by mail. In other words, we need to get those to the vice president into the well of the House of Representatives where they're counting these votes, that effort being made on the morning of January 6th, according to the allegations in this indictment. It goes on to say, when one of the senator's staffers contacted a staffer for the vice president, that's Mike Pence, by text message to arrange for delivery of what the senator's staffer had been told were an alternate slate or slates of electors for Michigan and Wisconsin, because the archivists didn't receive them, the vice president's staffers rejected them. They said no. And again, we saw a lot of that in the media at the time of these events being addressed and being revealed by members of our media. We saw a lot of that. And we know as a result of the consequences of that particular event that those electoral votes, those fraudulent votes from Wisconsin and Michigan and other states did not in the end affect the vote. Did the insurrection, the riot, suspend the counting? Absolutely. Absolutely, for hours on end, while some sense of calm and peace had to be restored. As a result of Mike Pence and a result of the commitment by the Speaker of the House of Representatives, Nancy Pelosi, and the leadership, candidly, there as well, a commitment not to give in. They returned late at night and said, we're going to continue with this process. We are going to count the legitimate votes, not the false votes. We don't know if they knew about the scheme at the time, but not the false votes, not the false electors. We're going to count, we're going to open the envelopes, and we're going to pursue this in a way that's legitimate under the Constitution, and they did that. So all these efforts, including this effort involving our senior senator, set forth in the allegations in this complaint, an attempt to try to undermine the process. In the end, none of it worked. None of it worked, as we well know in history. Does not mean, of course, that the crimes were not committed. And again, according to the allegations in the complaint against Donald Trump, what are those crimes? It's conspiracy to defraud the United States of America. Various methods that Donald Trump and his co-conspirators, the 6 of them, and certainly others as well, tried to overturn the results of the 2020 election. All these related efforts to obstruct the vote certification proceedings, including what we just recited here, involving trying to get our senior senator to get those false electoral votes onto the floor for counting. 2 charges there of vote certification proceedings violations, one of obstructing that process and one of conspiracy to do so. And then this other charge, again, premised upon all of this, a conspiracy to violate civil rights an attempt to reverse the election results in states with close elections. We know what those states are. They include the state of Wisconsin. And so all of that, again, set forth in this omnibus indictment, not as broad, not as sweeping as the one in Georgia, which leads me to a final question coming in from a good listener here from Mary from Mount Horeb, who asks about the extent to which, again, between the federal and the state system, she says, can Merrick Garland be involved in this in any way if indeed some of these attempts right now by Georgia by Georgia legislators, if they try to replace Fani Willis, to suspend her, to take her out, can Merrick Garland do something about that? The narrow answer is no, but that kind of a process, plainly illegal, plainly under state law, federal law, should be the subject of review by a state court, by a federal court, challenging anybody who would try to do that. We have spent a lot of time this morning. We'll continue this with our next broadcast, talking about the nuts and bolts, both of the state prosecution in Georgia and also significantly this federal prosecution. We're going to hear more about it on Monday. From a district court judge in the District of Columbia and the state court judge, federal judge in Georgia, telling us more about what happens down the road. Stay with us for those future discussions right here on Morning Cannolis. Have a good week, everybody.
I'm inclined to pursue